You know, when you live in a community with a homeowners association, you're agreeing to live by a certain set of rules. But what happens when you start to believe the people making the rules are the ones breaking them? Well, today we're going to unpack a wild legal fight where a group of homeowners took on their HOA, not just with one complaint, but on 6 different fronts.
So suing your HOA once? Yeah, that's a massive headache. But what happens when you sue them 6 times? That's not just a little disagreement anymore. That's a full-blown war. So how on earth did it get to this point?
Every battle has to have a battlefield, right? For this story, it's the Arizona Office of Administrative Hearings. This is where you go, officially, to challenge your HOA. And you should know, this isn't like some small claims court. It's a formal legal process, with a real judge making a final, binding decision.
And this whole thing didn't just start with one big explosion. Nope, it was more like a snowball rolling downhill, where one little complaint turned into a flurry of lawsuits, creating this tangled web of accusations that a judge had to figure out.
Just take a look at this timeline. The first petition gets filed in January. Then by August, another one lands. At this point, the judge sees what's happening and decides to consolidate the cases for what's called judicial economy, which is really just a fancy way of saying it's way more efficient to just deal with them all at once. But this was no quick fix. The whole process, from that first filing to the final day in court, dragged on for nearly a year and a half.
And that is the magic number here, 6. As more and more homeowners filed complaints, the judge eventually just bundled 6 separate petitions into one massive consolidated case. 6 different issues all rolled into one giant hearing.
So, you've got to be wondering, what were they even fighting about? Let's dive in and break down all 6 of these core disputes, one by one.
All right, first up, let's follow the money. The first big fight was all about a septic system fee. Sounds kind of dry, right? But the question was actually pretty simple. Who's supposed to be footing the bill? Okay, so the homeowner's side of this was pretty straightforward. They basically pulled out the community rulebook, the CC&Rs, and pointed to the line that said septic fees only apply to lots that actually have a house on them. But the HOA was charging every lot, even the empty ones. The HOA's defense? Well, they didn't really argue about what the rule said. Instead, they argued about what they thought the rule was supposed to mean.
Now for dispute number 2. You might kind of chuckle at this one. We're talking about a tiny reimbursement of just $75. But as you're about to see, this was all about the principle of the thing. The homeowners were saying, hey, you can't use our community funds for a replacement part. The rule's saying that's on the owner. And the HOA's comeback, well, they said the invoice was kind of fuzzy. They argued they couldn't tell if it was a repair, which they are allowed to cover, or a replacement. So they claimed that ambiguity gave them the green light to go ahead and pay it.
And this is the exact sentence from the rule book that this whole $75 argument hinged on. I mean, look how clearly it spells it out. Replacements shall be the responsibility of the owner. This wasn't some minor detail buried in the fine print. It was written in plain black and white, and the judge was definitely paying attention to it.
Okay, let's move on from the money to something that's just as important, due process. Dispute number 3 is all about playing fair when you're telling someone they've broken a rule.
So a homeowner gets a notice, right? It says they have to trim a tree, but the notice was missing something huge. It didn't say which rule they supposedly broke, which is actually required by state law. The HOA's defense was basically, oops, our bad. They didn't even try to argue that the notice was correct. They just said, hey, the new board president knows about this stuff and is working on fixing it for the future.
Now for a really big one, election integrity. Yeah, this 4th dispute gets right to the heart of how the whole community is governed, because it calls into question whether their board elections were actually secret.
So the community rules are super clear. Board elections must use a secret written ballot. But then the homeowners find out that after the election, the ballots were being stored still attached to the signed envelopes. I mean, you could literally just look and see how everyone voted. The HOA's defense was a real technicality. They basically said, well, the rule says the voting has to be secret, but it doesn't say anything about how we have to store them afterwards.
Look, in any big legal fight like this, you're going to have some wins and some losses. And this next dispute, this is the one where the homeowners didn't come out on top. It was all about a decision the board made behind closed doors. The board decided to file an insurance claim, but they did it during a closed session. The homeowners were like, hold on, that's a financial decision. You have to do that out in an open meeting. But the HOA pointed to a very specific exception in the state law. Because the claim was tied to a lawsuit with a homeowner, they were legally allowed to deal with it in private.
And that brings us to the final showdown, dispute number 6. This one is all about a simple idea, transparency. You know, a homeowner's fundamental right to see the association's records? So a homeowner, totally within their rights, asks for copies of some violation notices, with all the personal info blacked out, of course. The law is clear. The HOA has 10 business days to hand them over, but that deadline just blew right by. Nothing. What was the HOA's excuse? Their attorney told them to withhold the documents because of all the ongoing litigation. So after a year and a half of arguments, hearings, and all this legal wrangling, the moment of truth finally arrived. The judge issued a final verdict on all 6 disputes. Let's see how it all shook out.
And the verdict? Wow, it was a near total knockout for the homeowners. On the septic fees, the judge sided with the homeowners, that's a win. The $75 reimbursement, another win. The vague violation notice, yep, the judge ruled the HOA was in the wrong. The secret ballots, a huge win for homeowner rights. The judge said anonymity has to be protected, even in storage. The only loss was that closed-door meeting, where the judge agreed the board acted within its rights. But on the withheld records, the homeowners won again. So the final score? Homeowners 5, HOA 1.
And this victory wasn't just on paper. It came with a price tag for the HOA. The judge ordered them to reimburse the homeowners $3,500 for their filing fees. That's a real financial consequence for all their missteps.
You know, a case like this is so much more than just a neighborhood squabble. It's actually got some really powerful lessons for anyone who lives in an HOA, or is even thinking about it.
So what are the big takeaways here? First off, the written rules are king. The judge came back again and again to the exact wording in the community documents. Second, procedure really matters. The HOA couldn't get away with sending vague notices or just blowing past legal deadlines. Third, and this is so important, as a homeowner, you are not powerless. This case proves there is a formal legal path to challenge your HOA. And finally, an HOA's authority is not absolute. It has to operate within the limits set by its own rules and by state law. You know, when you strip away all the legal details, this entire sprawling case really boils down to one fundamental question. In a community where you own your home, but you agree to follow a set of shared rules, where's the line? Where does the association's power end and a homeowner's rights begin? This 6-count battle gives us some pretty clear answers, but it's a question every single homeowner and every HOA board needs to think about.